Hi and welcome to this revision video on theft, which is one of the main offences you have to learn under the OCR A-level law revision syllabus and specification. We're going to be looking at the Theft Act 1968, which covers theft and it's a trial by either way offence. And according to section 7, the maximum sentence is 7 years in prison. The definition is found in section 1 of the Theft Act and it sets out really clearly the definition as dishonestly appropriates property belonging to another with the intention to permanently deprive the owner of it. And you can see there the section numbers. Now it's quite an easy set of sections to learn, because if you know the definition as dishonestly appropriates property belonging to another with the intention to permanently deprive the owner of it, you therefore know the sections because they are in order. So 2 covers dishonesty, 3 appropriates for property, 5 belongs to another, 6 with the intention to permanently deprive the owner of it. So you can see there they do go in order. One of the classic mistakes though is people forget that section 1 just sets out the definition, and then they label section 1 as dishonesty and then get the rest wrong as they follow through with the definitions as they go. So really important there, you remember section 1's the definition, and then the rest you should get right with the right sections. It is useful to refer to them as sections and write in the exam the right sections, as it just shows wider knowledge and greater skill with the AO1 marks. If we look at dishonesty under section 2 next, the main case on this is RV Gosh, which set out the Gosh test, which is the main test you use to decide whether the defendant did act dishonestly or not in a theft. It is obviously part of the mens rea, because it's to do with what he was thinking at the time he did the offence, not what he actually did. The Gosh test is split into 2 parts. The first bit is whether the ordinary person would think it was dishonest, and the second part is whether the defendant thought it was dishonest. And the jury have to ask themselves those 2 questions and look at all the evidence, obviously, to make those decisions. The first bit, the ordinary person, is generally seen as the objective part, because it's looking at what the ordinary average person would think. And the second part of the test, looking at the defendant thought, is subjective. So that's the 2 sort of phrasing, the bits of phrasing they use for that. It's worth noting that recently the case of Ivy v Genting Casinos came out. It is a civil case, and we'll talk more about that later, but it has cast doubt on the second part of that test, the subjective part, about whether D would realise it was dishonest. So that's worth mentioning, particularly in an essay on this, but worth bearing in mind. Now, there are some exceptions to where defendant is not dishonest because of what he thought. So section 2.1a is D is not dishonest if he thought he had a legal right to appropriate the property. You can see that in the case of Holden, where he took tyres home thinking that he was allowed to from the place he worked. So he wasn't dishonest, so therefore it wasn't a theft. Section 2.1b, D is not dishonest if he thought the owner would consent. There's no real case for that one, but it's worth bearing in mind in terms of lessons and things like that. If someone was to borrow like a textbook, you'd probably think that they weren't dishonest because they think your like mate would consent to that. Section 2.1c covers D's not dishonest if he could not locate the owner by taking reasonable steps. So that's like if you find a wallet on the street or a purse. Obviously, if it's got like an ID in, you could actually find the owner. So in theory, if you take that is actually theft. You are being dishonest. Whereas if you found £10 on the street and you didn't see anyone drop it, it's just there, you wouldn't be able to locate the owner through reasonable steps. So you would be able to take that. And that's covered by the case of Small, which is a bit of an odd case, but a car's abandoned basically on the street for a number of days or a week. And there's no way to trace the owner. So when the guy took it, that wasn't dishonest. So therefore it wasn't theft. Okay, so this section covers appropriation. So it's whether D basically takes the property. Now that is the dictionary definition of appropriation, but you can see here that actually the courts have given a wider definition to include assuming the rights of the owner from the case of Morris. That's a case where the defendant switched price labels, so they weren't actually taking anything in theory, like a normal theft you'd think of, but that was theft according to the courts because only the owner had the right to switch the labels. So D was assuming the rights of the owner. In Takper and Abrahams, that was the Brussels car theft one, where they're taking cars from abroad and bringing them into this country. They said theft is not a continuing act, so the theft actually occurred in Brussels and they couldn't be convicted of theft in this country. So it's worth bearing that in mind. It comes up again as relevant AO3 in a bit with regards to looking at robbery. Lawrence, there was a theft in that case and it wasn't consent. The defendant tried to argue in that case that the Italian student had consented to giving him the money because he held out his wallet and his money, but he in fact did take more than the fare and charged him a larger fare than actually was due anyway, so that was theft. In Hinks, very important case, it was a theft as the victim was actually conned. So it was a con woman who conned this man out of TV and money. And although he essentially consented to giving it to her, the court said it wasn't real consent and it was indeed still a theft. And that is relevant later with AO3, as well. We'll come back to that. Pittham and Hell, he did assume the rights of the owner when he tried to sell the furniture. That is a popular case they use in the exam. I've seen that across many of the years on the previous specification. So it's worth bearing in mind that one as an extra little case, just in case they go with similar facts. Section 4 covers property. Section 4.1 gives the sort of standard definition, includes up money, tangible, which are things you can touch, etc. It does include things that are intangible or things in action as well, so it's worth knowing that bit of the definition. It's fairly vague, fairly wide. It covers most things, obviously. One thing it doesn't cover, according to Oxford v Moss, is information. And again, that will come up with the AO3 later in terms of the relevance of copyright and things like that. There are two extra sections which are really important for property, section 4.3 and section 4.4. Section 4.3 covers sort of foliage, mushrooms, flowers. If you pick wild mushrooms, flowers, foliage, that's not theft unless it is for sale or reward. So look out in the exam for if they're sort of selling, they pick sort of wild flowers or whatever and they sell them, that could in fact still be theft. Section 4.4 covers animals. Generally, to take a wild animal, that's not theft, unless they've been tamed during captivity. So if you took someone's dog or cat or hamster, that of course would be theft. If you took a penguin from the zoo that's in captivity, that of course would be theft as well. But think perhaps of like a wild rabbit, if you're taking that, that's probably not going to be theft. Although with a lot of animals, you've got to bear in mind there are other laws to do with poaching and things like that as well. So, but under theft, it wouldn't necessarily be. The last case for property that's worth knowing is R.V. Kelly. It was to do with body parts that were taken from a laboratory in a university. Now, body parts are generally not property, and it's worth bearing that in mind, and it's for general reasons to do with if you owned like your liver and your kidneys and things, you in fact could sell them, and they don't obviously want that, although there are issues on the black market and things like that. You can't do that for various reasons. But in this case, because the body parts were being used for a particular purpose, so e.g. like in a museum or a laboratory, so if you think of like a mummy in a museum, they can in fact be property. So if someone was to steal a mummy from a museum, that would class as property, even though the body parts normally aren't property. In terms of section 5 belonging to another, section 5.1 gives the definition again. It labels three things really: control, possession, or proprietary right. So that gives you a sort of an idea of when something will belong to someone else. Turner's a bit of a weird case. She took her car from a garage and didn't pay for the repair work that had been done. And she was found guilty of essentially stealing her own property. They said the car belonged to the garage in essence. It didn't really make any sense. They did it because obviously they wanted to be able to convict her, and she did steal the money that was owed for the repair works, but it just doesn't quite work with the definition. Now, 10 years later, in the Theft Act 1978, they closed this loophole by introducing making off without payment, which is a much more accurate offence of what's actually happening there. She's making off without paying for the repairs, and that makes a lot more sense and has improved the law significantly with that by closing a sort of silly loophole, really. There are other two sections that you do need to know. Section 5.3, which covers purpose. So if you give money or something to somebody for a particular purpose, it still actually belongs to the person that gave it to them. So, for instance, in Davidge v Bennett, she was given money to pay for the gas bill, and she used it to buy Christmas presents instead. Now, although she was in control and possession of the money, which if you look at section 5.1 would suggest it belongs to her, the court said, the court said in Davidge v Bennett, and also section 5.3 makes very clear that because it was given to her for a particular purpose, because she didn't use it for that purpose, it still belonged to the person that gave it to her. Section 5.4 covers mistake. So if you obtain property by mistake, it still belongs to the person that sort of made the mistake. So in AG's reference, she had money overpaid into her account. She refused to give it back. They said it's still, even though she was in control, possession of the money in theory, because it was in her account. So again, if you look at section 5.1, it still belonged to the person that made the mistake, so the person's account that it come from. So it's worth bearing that in mind. In the exam, they typically use those two. They're very common to come up as issues. Section 5.4, commonly it's sort of around where you get extra change. So you might give change for £10, but they think you've given change for 20, so they'll give you change for 20 even. And if obviously the defendant realises they are perhaps being dishonest under the Gosh test, etc., and although they're in control possession of the money at that point, it still belongs to the person that made that mistake because of section 5.4 in AT's reference. There are two other cases there that can come up as well. So Ricketts v Basildon Magistrates, quite a common case to be relevant. That was where they left a bag of clothing for a charity and someone took it, and it was an issue as to who it belonged to, and it's very clear that it belongs to the donator, so the donor, until it's sort of taken or picked up by the donee. So in that case, it still belonged to the person that dropped off the bag of clothes, and it would have done until the morning or whenever actually the people came in and took the bag into the charity shop. So that's worth bearing in mind. Quite often seen that on the old specification where perhaps somebody that leaves like a flower, I think one of the exam questions, and they leave a bunch of flowers on the doorstep and someone takes them, and obviously they still belong to the person that put them on the doorstep. Rostron, it's the idea that seemingly abandoned property can still belong to the owner. So in that case, there was a guy who took all the golf balls from a lake, from a golf club, and although they were seemingly abandoned, they still actually belonged to the golf club, and that was still theft. Okay, section 6 covers with the intention to permanently deprive the owner of it. This is largely seen as a bit of the mens rea as well, so obviously this goes with dishonesty, and then the actus reus is really the act of appropriating property belonging to another. With regards to section 6, this bit, you've got to distinguish it from borrowing. So in Lloyd, we saw where he borrowed the film and he had the intention to return it, so it wasn't theft. But you've got to be aware of where borrowing becomes an outright taking. So you've got to make sure that actually it hasn't become sort of intention to permanently deprive because of taking so much of that particular thing. Good example would be like a pen using up all the ink, although it'd be very minor. Quite often I've seen before where they use like a football season ticket and use up most of the seats apart from like one. You'd have to make an argument there in the exam as to whether that was just borrowing or was intention to permanently deprive the owner of it, with probably no right or wrong answer there as long as you're able to justify it. Villeneuve, obviously he couldn't return the exact same notes that he took from the till or the safe. Doesn't really quite fit the definition because he obviously did intend to return the money, but they obviously wanted to convict because it wasn't an okay thing to do. Quite obviously in a business we have to take money out without asking anyone, without any consent really there. So they did find him guilty and obviously twisted the law slightly there, which I'll talk about again in the O3 in a minute. Same sort of situation in Lavender. Although technically didn't permit deprive the council of the doors, as he took the doors and they put them on his council house, the court said he treated them as his own and therefore it was theft. So it's worth bearing that in mind as well. It might not quite fit the definition, but quite often if it links to a case, that's relevant as well. The two main ones there are probably Lloyd and Villeneuve to watch out for in the exam. In terms of AO3, what I've got here is you can see 5 points there and 5 points on the next page with, as I mentioned, about the conclusion. These are jumping off points, so they're really good bits of AO3 that you can sort of jump off from and talk about more details. So certainly I wouldn't just put these as the 10 points and that is it. You obviously want to have a wider discussion from them. They are in order in terms of how I would probably write the essay. So starting with the first one, the theft act is actually probably a positive. That it's really well consolidated really and easy to find the law compared to other areas of law. If you compare it to a lot of the areas of common law, like murder, or perhaps even non-fatal offences covered by OPA, which has sections in it certainly, but it's all a bit hickety-pickerty and not quite clear as to what the law is and the definitions and things. The Theft Act, by comparison, has definitions within it. You know, they might be wide and fairly vague, but they are in the Theft Act. And obviously with the sections being clearly laid out like they are, it makes it quite easy to understand and know the law really for it. The second, and this is probably the first big issue, is with the term dishonesty. Obviously that is a moral concept. People are going to have different ideas of what is dishonest and what is honest, and they might have differences with even the 12 jurors or the magistrates as well if it goes to the magistrates court. So that can be quite an issue in terms of getting consistency in cases and things like that. It's further exacerbated or made worse by the ruling in Ivy v Genting Casinos. Now, although that is a civil law case and not binding, and that's really worth bearing in mind, some of the sort of things, reports and stuff on the internet are quite misleading with that. It is highly persuasive as it was a Supreme Court decision. Now, obviously, that doesn't directly affect Gosh today. The law still is Gosh in criminal law, but it's worth bearing in mind that that might change in the near future. if Gosh is appealed and looked at perhaps by the Supreme Court. The final issue of dishonesty is expecting the jury to put themselves, or the magistrates to put themselves in the shoes of another. You know, it can be quite difficult to actually put yourself in that situation and decide whether you would think it was dishonest and things like that. Number 3, obviously the definitions of many of these sections are actually really wide and fairly vague. So appropriation, property, belong to another, and intention to permanently deprive. In all of them, the judges have really had to step in and provide further definition because the statute isn't super clear. So appropriation, for instance, means, under the dictionary definition, means taking. Now, obviously, that wouldn't cover things like in Morris, where he swapped the price labels necessarily. So they've had to sort of go with the assuming the rights of the owner part to sort of cover those sort of cases. Similar with property, belonging to another, they've had to sort of expand beyond just control and possession, as that again clearly doesn't show issues. And you had the issue there as well with Turner and Stephen property, which I'll again mention in a minute. Attack and Abrahams, the idea that theft is not a continuing act, which is perfectly fine in Attack and Abrahams and makes sense. The difficulty is, under robbery, theft is a continuing act, and that's within the same act, the Theft Act. So it seems a bit disparate, or doesn't quite make sense that it can be a continuing act in one and not a continuing act in the other. And you can see they really clearly did that in R.V. Hale for robbery because they did want to convict, so they sort of mentioned that it was a continuing act there. But that has, potentially presented problems there in it being different for the two offences. Hinks. Under civil law, the gifts that she received as the conwoman actually legally under civil law belong to her. So there is an issue there as to how can she be guilty of stealing them if she now legally owns them. So there is a bit of an issue there, but obviously in terms of public policy, they obviously want to deal with situations where someone's been conned out of things, because obviously that in itself is sort of a crime or morally wrong as well. Number 6. Oxford v Moss, is it really fair that information is not property? In that case, she did basically steal that information. But bear that in mind, it doesn't really matter that information is not property, because in most instances that information will be copyrighted. Exam papers, for instance, are now copyrighted. So there is another means of dealing with that issue rather than perhaps criminal. Although it's still worth bearing in mind is should that be different, should it? But again, the major difficulty of the practicalities of proving that someone actually knew the information. You wouldn't be able to prove beyond reasonable doubt that they knew the information, because you can't tell, you can't do a brain scan and know whether they actually know it or not. So there's a difficulty there in what they've actually stolen. 7 covers Turner and how was Dee actually guilty of stealing her own property. And I've mentioned this before. And the fact that it's been significantly improved by introducing the Theft Act 1958, making up for that payment offence, which is much more clear as to what's going on there. So that's sort of a fixed issue, really, but worth mentioning. Under the case of Lloyd and borrowing, there are issues with the definition of permanently deprive and the idea that borrowing becomes an outright taking. There are a lot of academics that say that surely the taking is enough. Why does it have to be permanent? And of course you can distinguish from borrowing and take that out of the cases, but why does it have to be intention to permanently deprive? Surely taking something from someone without their permission, even for any regard of time, is surely a theft. So it's worth bearing that in mind. Volumnal, again, it didn't really quite fit the definition. The fact that, he did intend to return that money. So for public policy reasons, they don't want to allow that. They found him guilty, and they twist the law by sort of saying this silly thing about you can't return the exact same notes. I mean, it makes sense, but it is still a bit silly and doesn't really quite work with the law. 10, Lavender, again, you can see the definition of this intention of permanently deprive not really working because he didn't officially, technically, deprive the council of the doors. So the judges had to sort of rejig the definition to treating it as his own, which is just sort of moving away from the actual legal statutory definition. So there's a lot of judge-made law there, and judges are having to make decisions as to what things that mean within the definitions because they are so wide. But it does mean that theft is a really sort of open offence now, which covers a wide variety of things, which is probably good, because in most of these instances, the defendant is in the wrong and has done something which most people would consider to be criminal. Now, obviously, in an essay, you have to have a conclusion. You really want a conclusion to get the best possible marks. So in there, you're looking to sum up and answer the question, specifically using the terminology of the question, and ideally include 1 or 2 reform proposals. ideally from the Law Commission or other bodies, but equally you can make a suggestion of your own, a reasonable suggestion about what could be changed and developed. In terms of scenarios, let's pick the order of how to do this. Obviously, you've got to determine how many thefts have taken place. What you then want to do is write out your AO1, including all relevant cases. And then for each person where you've identified there's been a theft, you want to methodically work through each part of the test, so sections 2 to 6, using the terminology. So, mention the GOSH test, use the word appropriation, assuming the rights of the owner, use the term property, and refer to relevant sections in cases where possible. So if you're mentioning about plants and things under property, mention section 4.3 in your AO2. If you're talking about obtaining it belonging to another, the mistake part, mention section 5.4 there. So really be clear and tie in what you're talking about to show a really good legal argument. Obviously, again, you want to reach a conclusion using the language from the question, and that's really, really important. Again, just to make it clear to the examiner that that's what you're covering and you're answering the actual question set. And that is it for this theft revision video. So I hope you enjoyed that. I hope you found it useful. And if you did, subscribe. And there'll be more videos coming up covering all the range of topics across contract law, tort law, criminal law, and also the topics like English legal system and lawmaking, things like that. Thank you very much.